humbly request our next speaker, Shri GR Raghavender, Joint Secretary, National Mission for Justice, Delivery and Legal Reforms. Shri GR Raghavender is a civil servant from the Central Secretariat Service 1988. At present, he is Joint Secretary, Department of Justice, Ministry of Law and Justice since January 2017. He is policy reforms for improving enforcing contracts parameter under the ease of doing business and e-courts projects. Earlier, he was Joint Secretary in Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India, New Delhi. There he also held additional charge of Director General, National Productivity Council from December 2015 to May 2016. He is former Registrar of Copyright of the Indian Copyright Office. He played a key role in the introduction of recent amendments to the Copyright Act in 2012 and the Copyright Rules 2013. He attended many Wipro SCCR meetings and FTA negotiations as a member of the Indian delegation. He made significant contributions to recently concluded two WIPO treaties, namely Beijing Treaty on Audio-Visual Performances 2012 and the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise disabled 2013. He has contributed in revision of the copyright legislature of Bhutan, Myanmar, and Nepal as a copyright expert. So with these words, may I invite Shri GR Raghavender.
Yeah. Honorable Justice KG Balkrishnan and former Chief Justice of India, and respected Sri Adesh Agarwalji from International Council of Jurists, and Honorable Professor Raj Dankar, my friends Professor Sarfraj and Professor Kavita, and other participants, and various law teachers and research scholars and law students attending this event. And thanks a lot, Professor Shobna, inviting me to this international e-seminar on contemporary legal issues and challenges. As a student of intellectual property rights, I was a little tempted to talk about copyright issues pertaining to this kind of online webinars and online teaching. Later, I was thinking about how about talking about the patents and access to medicines, because a lot of research is going on COVID vaccines and COVID medicines, but I'm restraining myself to very important issues, the disruptive legal reforms which Supreme Court has introduced. Many people do not know how during this COVID pandemic lockdown, courts are functioning normally. Judges are sitting, working, and hearing the cases using the virtual courts, and online hearings happening, and e-filing is happening. Everything happening in this new normal. The judges are trying to promote that there is a new normal thing is happening, even this COVID lockdown. Of course, the hearings are restricted to only the important hearings. The normal hearings are not happening. But despite that, in the criminal cases, the bail is happening. That is very, very important. And then various other important cases, right from the Supreme Court, and there are 25 high courts and more than 3,000 district and subordinate court complexes. They are still working. And I know I'm speaking not in the capacity representing the department, but in my personal capacity I'm speaking. So I'm so thrilled how the entire infrastructure which has been provided to the courts have been utilized maximum to impart the access to justice. Access to justice, not only the haves, even the have-nots, the most marginalized people are also getting justice during this lockdown and COVID times. It all happened way back in 2005 when the E Committee of the Supreme Court floated a vision document called National Policy and Action Plan for Implementation of Information Communication Technology for Judiciary. So it envisaged few actionable reforms like digitization and computerization of all the courts, and then connecting the courts with a National Judicial Datagrade, which provides the data. Those who are not aware about the National Judicial Datagrade, which is a huge, humongous database, was created during the phase 1 of the e-courts project. It has more than 10 crore case laws available, and more than 9 crore orders of these cases available, both civil and criminal cases. If you go and Google it and go to this portal, National Judicial Datagrade, you get the real-time information of pendency of cases. If you just see the district and subordinated courts, there are 3.24 crore cases, both civil and criminal are there. Of course, criminal are more. 2 crore cases, around 2 crore cases out of the 3.2 crore pending cases. There are more than 45 lakh cases pending in 25 high courts. This data is available. So entire this data is available in a case information system software 3.2. Earlier it was 3.0 and migrated to the latest version 3.2. So apart from this, providing citizen-centric courts, district courts and subordinate courts, they started installing kiosks, e-kiosks, where a lawyer, a litigant walking through the corridor, go to that kiosk, there is a smart desk is there, and then he simply flip through his fingers, find out what is the cause list, in which court his case is coming, which judge is sitting there. So normally the cause list you find on the wall of the court door, you find all this information in a kiosk made available in the court complex in the corridor. Now, so this kind of disruption has happened. And another important thing is providing robust digitized data management in the courts. This has been done. And while introducing computerizing the courts, introducing the ICT facility, and connecting the courts with the internet facility and improving the land system, in the first phase of the e-courts project, when the center has approved and cabinet has approved and started giving the funds from 2011 to 15, the phase 1 started. When phase 1 started, 14,249 courts were computerized in India, I'm talking about. So total, each and district and subordinate court was computerized. Land facility was given to around 14,000 courts, and judges, judicial officers, even lowest of the lowest judicial officer were given the laptop facility. Apart from the the desktop he has in his, not only in the chamber, in the court hall. So about 15,000 laptops were distributed to these judicial officers officially. And not only just giving the technology and making the digitization work, but there is a policy reform which Supreme Court E-Committee introduced, that is the change management. So training these judges to use this technology and software, so that all these electronic case management tools. So what are these tools made available? Now judge can go and select the calendar, do the scheduling. When lawyer is arguing before him, he seeks the adjournment, immediately he can give the date. He need not depend upon the diary which his clerk is holding. He simply click the computer, select that tool, and click the date and allot based on CNR number, he will allot that date. So and then he can, when he delivering the orders, he need not dictate and everything. Some ready-made model templates have been provided to him. Whichever relevant template for that case, that matter, he can select, simply fill up the information of the case, both the parties' names, and then he can sign the document, few correction he wants to make, and that kind of ready-made template judgments for common orders have been provided. And you can see, you can access more than 800 laws. So India Code, which is managed and developed a portal which has more than 800 laws and regulations of the legislative department of law ministry, that has been made available with the click of the button. The judges need not go out of the e-code portal to access that and get into that. So automatically, because APIs have been shared, the data have been drawn here, and apart from that, he wants to know what is the section 302 of the IPC. If he simply types that, it says whether is the cognizable offense, non-cognizable offense, what is the fine imposed, what is the imprisonment. So a kind of brief is given, or he wants to read entire section 302, he can access the law and then read it within seconds. Lawyers are aware, standing, judges asking the books, barracks, and assistants providing that. Lot of time is wasted there, course time. So within no time, he can just browse through these things and then refresh his mind and refresh his knowledge about those provisions and those legislation. He can see entire case history. So about so many hearings happen. You need not read entire physical file and then see what. Within a glance, he'll know that last two hearings, why it was adjourned, what was the reasons from the both parties seeking the adjournment, and if some arguments have taken place, what is the focus of those arguments. Everything he can get, that kind of information is being made available to him. And then the next step and training of these judges happening. The master trainers, recently a concept of master trainers, the E-committee has started. They train in Delhi and Mumbai, they train 50 judges. These 50 judges are going to be master trainers. They're going to train further 50 judges. Similarly, a training of lawyers have been started in Delhi and Mumbai. For example, e-filing is started, online training of workshop. You can go click on YouTube and get those videos, how e-filing can be done. So e-filing, e-summons are the new norms which is being implemented under the e-courts project. When e-courts 2 phase started in 2015, the further development started, and then e-courts phase 2, every year around 250 crores were allocated by the government. It has been fully utilized by the courts, Supreme Court, almost. In the e-courts phase 2, 16,845 ICT enabled courts have been created, and then few courts were left out, about 4,992 courts selected, because the bandwidth was beginning with the 2 Mbps. So it's been increased to 10 Mbps minimum and to 60 or 70. And then areas like hill areas, northeast areas where laying of fiber optics is difficult. So satellite, through satellite, the internet connection has been provided to northeastern courts where fiber optics cannot be laid and all that. Professor Kavita was talking about the virtual courts. How these courts suddenly started working. The lockdown started in the last week of March. Infrastructure was not provided from the March. It was already existing, so that the judges can open that and then start using it to improve the access to justice during the COVID times. So in the first phase, 448 courts were provided with the video conference facility. In a phase 2, this has been increased to 3,240 court complexes. From 440 to 3,240 complexes is increased. How about the jails? Every time police have to take the inmates to the court for evidence recording and various other things. So it is always risky. That's what everyone talk about, encounters and the criminals running away from the clutches of police and all that. So to avoid this, E-committee has planned video conference facility to be provided in the jails itself. In the phase 1 till 2015, 342 jails were equipped with the e-conference facilities, video conference facilities. In the phase 2, this has increased from 342 to 1272 jails in India have that facility, video conferencing. And this is an ongoing work. The more and more jails will be equipped with that. I had the opportunity to visit last year in the same time. I just wanted to go and see how these systems are working in the Tihar jail. And I've seen it's working perfectly, all right. And the witness protection also was being talked about by Professor Kavita. And then in the 15th Finance Commission, we have sent a proposal that most of the courts should be provided with the witness protection centers with the video conference facility, so that the witnesses and victims should not be brought before the perpetrator of that crime and violence. So in Delhi, most of the district court complex, you go to Dwarka or Saket or anywhere, you have these beautiful rooms have been made where POSCO victims like children can also be placed, their relatives and their mother or parent can sit, and then where the criminal won't be knowing. So from where this video recording happening with the judges when criminal is made present before the judge in the court. So all these facilities are being provided. So most beautiful aspect of the e-courts project is providing the facility to the lawyers. So many times lawyers think that they are left out, and they also think that the marginalized people are not getting this. So e-court services portal not only provides the 8 case management tools I was explaining about the judges. Judges can log in through their laptops and desktop, and also they can download an app. One Justice app has been created especially for judges. More than 14,000 judges have downloaded this Android app. Few have downloaded iOS app. So all the facilities which are available to the portal, same data can be fetched. Sitting at a home in the drawing room or traveling in the car, judge can go through, open his and log in and open his, and then in the court hall, what are the cases that particular day placed before him in that bench. He can go through that. Yeah, he can flip through the files. He can browse through the files while reaching the court. If any important case in his mind, he can simply go through that. Okay, what I'm going to plan, how I'm going to schedule this. Especially, in the CMCJ's conference in 2016, all the Honorable Chief Justice of High Courts and then Chief Minister decided that 5+0 policy, the cases pending more than 5 years should be given more focus. They said area committees have to be created. Supreme Court has an area committee. All 25 high courts have an area committee. Even district and subordinate courts have area committees. So these are focusing on the cases more than 5 years. If you see the NJDG data, whether you go to civil case or criminal case, you select your own district. From whichever place you hail from in India, you go to that state, you go to that district in the NJDG, whether civil or criminal, see cases more than 2 years, 5 years, 10 years, 20 years. You can drill down to the last hearing. You can see entire history. So not only judges and lawyers, even a common man can see this humongous data, and this facility has been provided and the e-courts project NJDG. So what facility lawyers have? Lawyers have, they can access information in 7 ways. Number 1, they can download e-services app, e-court services app, either by Android or by iOS App Store. So this provides facility. It gives the cause list, it gives the case information, history, and my cases. You can register, and then if a lawyer is dealing with 60 cases, all 60 cases information is available there. And there is a QR code facility. He can create a QR code for each case and then take a printout and paste on the physical file. And whenever he wants to know what is the status of this case, with the mobile, that app has a scanning facility. We just can scan and see it gets pulse of the real-time information. And then apart from that, there is a SMS pull facilities there. So what lawyer has to do? Each case has a CNR number, case case number record. So this CNR number he has to SMS to a telephone number, dedicated telephone number called 919766899899. So the moment he gets this SMS sent, so he can pull out information about that case entire. It sends a link, automatic link. You can browse through that case. What is the status? When it is going to be listed? What happened in the last hearing? So entire information he can get. And another is SMS push facility. Under this, he can register the case. And instead of pulling the information every time sending SMS, he can register his mobile number. So automatically information about the 60 or 70 cases which he is dealing, all information get pushed to him. So he gets all the ready-made, up-to-date information about all his cases. There are information kiosks, already told you, which have been established in the court complexes. And then there is emails have been sent, mind-boggling. More than 10 crore emails have been sent through this system to the advocates till now who are registered about the case information and case law and all that. So all these disruptive things are happening under the e-courts project. And then most important thing is virtual courts. You know that virtual courts have been started recently, but not during the COVID times. Those who are not aware, I would like to tell you that virtual courts portal existed before COVID pandemic started. Many high courts started experimenting with these virtual courts, mostly in the urban and metro cities. For instance, in Delhi, traffic virtual courts started. It's really a disruption. Initially, it started with a policeman stopping the violator and channeling him. And instead of going and paying the fee, he used to pay using that virtual court. Now, they all CCTV cameras which pick up the traffic violations. That feed is sent automatically to the virtual courts based on the registration number of that violator. And then if he wants to compound that offense, that violation, and they want to pay the fee, they can pay the fee and finish off. Or he can face the judge in the virtual court without the help of lawyer sometimes. So that kind of facility has been provided. And then, e-filing is happening during this COVID pandemic. So e-filing concept started long back. Honorable Justice Dept Mishra, the then Chief Justice of India, launched e-filing portal in August 2018 itself. So this has been under development, and e-filing first software started using in Delhi and Mumbai and various other places. And then e-filing already began, and then now Supreme Court has demonstrated e-filing version 2.0. Honorable Justice Bobde, Chief Justice of India, Honorable Justice Chandra Buchur, who is the chairman of the E-Committee of the Supreme Court, both with the help of my friend, brother, judicial officer, Ashwant Goswami, he is a district judge from Maharashtra. He demonstrated that live. So how this disruptive element of e-filing 2.0 is coming. So you can file anytime, anywhere, sitting in your drawing room. You cannot rush to the court, standing at the window, or send your boy to file it. So any document, caveat, affidavit, written statement, evidence can be filed through affidavit, can be filed anytime, anywhere. So Delhi High Court also launched a similar thing, and 2.0 will be operationalized soon. And the payment of court fee has been made available through debit card, credit card, UPI, internet banking, and even by Paytm. So these kind of facilities have been provided to the lawyers and then litigants. So a lot of disruption is happening, and a couple of young lawyers have rang me up and thanking me for this initiative taken by the department. And then I said, the entire work is done by the E-Committee of the Supreme Court with the help of National Informatics Center. What department is doing is only monitoring and providing the funds under the budget heading of the e-courts project. Salute to all the judges who are driving these disruptive technologies to be introduced in the courts so that court functioning can happen. Access to justice can happen as envisaged in the preamble and the Constitution, that justice social, political, and economic. And as the difference is from the way you view these kind of reforms. When Dronacharya sent Yudhishthir and Duryodhana to Deshatan to get the people's perspective before you become kings, Duryodhana came back and said, all are bad people in the world. No, I didn't find a good person in the world. And Yudhishthir came back and said that I could not find a single bad person. I found everyone is a beautiful soul. So it all depends on you, the way you look at the reforms. If you want to go on criticizing, you can't be criticizing even the best of the best things, or you want to see the silver lining in the cloud that you can see. So another disruptive element recently happened. The Supreme Court judgment through Pradyumna Bish case. So CCTV facilities have been provided in most of the district and subordinate courts. And then Supreme Court has taken a a decision in a PIL filed by Swapnil Tripathi, Indira Jaising, and Matthew Nadumra, 3 separate PIL files. Supreme Court decided in this case that live streaming should happen in the issues of constitutional importance and constitutional question comes. At least in the court number 1, this should happen. And with the help of our Attorney General K.K. Venugopal, we have drafted the guidelines, and the guidelines are being reviewed, and electronic evidence also being reviewed. This will be finalized. So people may question, how about the access to justice to the marginalized people? Yeah, there is a scheme introduced by the department called Tele-Law Scheme. So what is this Tele-Law Scheme? Those who are aware that there are more than 2.5 lakh common service centers are there, even in the villages, 2.5 lakh common service centers. Village level entrepreneurs are manning. They have the internet facility and the printer and computer and all these facility, video conferencing facility and all that. So the law minister, being a IT minister, he thought, why not use this for improving the access to justice? So the scheme says that the paralegal volunteer of the under the NALSA, DALSA, and SALSA, these gentlemen and women, they go to find out marginalized people who are in the need of justice. Maybe the BPL people, or maybe women. The women suffered because of trafficking, which Professor Sarfaraj was talking about, or victims of domestic violence, or victims of land grabbing, victims of Gundaism, or any kind of crime, but they don't have wherewithal. They don't have money to approach the court, because approaching courts is very expensive, and also they can't engage lawyers. So these kind of poor and marginalized, free legal service is given under this scheme. And paralegal volunteer brings them to common service center and then make him to talk to a panel of advocates, either through telephone or video conferencing. After hearing his trouble, and then he takes note the notes, prepare a case, and gives it to the lawyer under the legal services authority. He will do the pro bono work. Even people who are above the poverty line can go and get these services, but with the minimum payment of fee of 30 rupees. So 30 rupees, a poor guy getting a lawyer. So this is a beautiful service available called Tele-Law Service in the common service centers. This system is working so excellently in 29,000 panchayats. Till now, 224 people have registered seeking help. This number has increased during the COVID pandemic times. Even in COVID pandemic times, Tele-Law Scheme has come as a great access to justice scheme for the poor and needy and marginalized. And how many number of women got justice out of this 224? More than 75,000 are women only who got justice. And the legal advice has been given out of 224, 211 cases. Advice have already been provided. The petitions have already been filed. Is all doing pro bono. So I request the lawyers, young lawyers listening, participating in this seminar, there is a scheme launched by Honorable Ravi Shankar Prasad, Law Minister. It's his idea to bring the young lawyers, promote the pro bono scheme of lawyering to help the poor and needy. So there is a mobile app available. You can go to Department of Justice or you can go to Play Store, download Nyaya Bandhu mobile app. Nyaya Bandhu. I request all lawyers download this, do the free legal service to poor and needy who really need legal help. So far only 1,700 lawyers have registered in this, and more than 800 cases pro bono service have been given to them. So even government, the department gives some, under the grievances mechanism, people approaching government. So we need justice and all that. These cases we transfer to those lawyers who already registered. They can also do the pro bono work. So technology is being leveraged in the tele-law service, bringing the poorest of the poor and the remote village, taking them to nearby common service center and providing the legal help to the panel of lawyers, either by telephone or video service, and then filing the cases, and then bringing the interested young lawyers or any lawyer to join this pro bono league to help the poor and needy. And so the technologies are being leveraged by the judges and the government departments, and our request everyone listening to that, contribute from your side, also play a key role, become a light on a focus to improving the access to justice in India, especially during the COVID pandemic times. And thanks a lot. It's an honor to be in the company of Justice K.G. Balachandranji. And I had the opportunity to share with you the bench in the Indian Law Institute recently in the month of November. And thanks, Shobhanaji. Thanks a lot to everyone. Thanks.
Thank you so much, sir. Thank you so much.